So I welcome you. So today we are looking at MCS Act 1960. This is a basic act on which we are functioning, or based on which we are actually doing lot of work. So there are various segments in which we will be able to go through this act and try to understand what exactly it has, so that practically when the client comes to us, what we need to do. So first of all, let us, before going to MCS Act, generally I just would like to have some feedback from you. What is that in any act when we take up? What is that you look at the act? What is that the purpose of that act? Can you say why, or what is that which we call it as the main purpose of the act, that is objectives or the purpose? So we need to understand whenever we pick up any act, what is the basic need of that act, what is the purpose of that act. So this, if we are able to analyze looking at the act, that gives you lot of comfort. Second comes, basically once I say what is the purpose of the act, the next we look at the jurisdiction of this act or application, or what we can, whom it is applicable, or applicable jurisdiction. When I say jurisdiction, whether this law is applicable for municipal local authority, whether this law is applicable to all over India, is it applicable in Maharashtra? So the jurisdiction of the act, whom it is applicable, where it is applicable, rather I would say where. So first is what is this act all about, and where it is applicable. Then the next is comes actually whom it is applicable. That means the next question is, who are the stakeholders in that act? Am I correct? When I say stakeholders, who are the people whom this act is applicable, whom it is applicable? I can call it as whom, to whom it is applicable. So what is it is, where it is applicable, whom it is applicable. Then the next, in the law, any law you pick up, the next thing which need to be looked at is what are the obligations, duties, role, responsibilities of the stakeholders. That means when you look at, the moment I say it is applicable to so and so stakeholder, let us say it is applicable to the cooperative societies, this is applicable to the members, it is applicable to the registrar. So we understood whom it is applicable. The next we look at what are the obligations on each of the stakeholders cast on that act. Am I clear? Yes. So the next is obligation, duties and responsibilities cast on a particular stakeholder. That once we say that these are the obligations, duties, responsibilities cast on the stakeholder, then we have to look at whom it is reported. That is called compliance. What are the compliance need to be done or reporting? Are you with me? So that means each stakeholder whom they are required to, what they are required to do. So once we say what are they are required to be done, what is their role, once we understand the role and responsibilities, obligations, then compliance. What need to be complied. The next, once I say the obligations, that also is a part of compliance. Once I said compliance, then naturally it comes the obligations, duties, responsibility and compliance. Who will monitor it? That is called, who is the authority? Who will monitor? Who is the monitoring authority? Or we can call it as an authority. Okay, whom it is accountable, responsible. So once we know these are the role and responsibility, these are the compliance, this is the authority, then naturally why the law comes? Because as per the law certain things have to be complied. It has to be looked into or abided by the person whom it is applicable. Once we said that, that means if their obligations are not met, they do not perform their duties, they do not do the compliance, then naturally we can go to the authority. That means redressal of the grievances or complaints. So complaint redressal is the next thing which need to be looked into in any law. Once we look at the complaints redressal, who is the authority or the person against whom we can make a complaint, and who is that authority, what are the complaints that can be done, and that complaints naturally comes from the obligations. Now, it is not necessarily that every authority does their job properly. Again, there can be error and omissions. That authority may not be, perfect. So the law provides that once we have an authority, naturally that authority, the order passed by that authority, or the grievances or the certain things which is addressed by that authority, if the person is not happy, then that authority, there can be appeal also, appellate authority. So there can be an appeal. So the appeal can be there. Now, the authority and the appeal. Then the constitution also provides us, after the appeal, there can be revision. So the appeal is also there, there is a revision also. Then of course, under the Constitution of India, we have Article 226 and 227, where we can go to the what is known as the writ petition against the particular order passed by the authority, and then of course we can go to the special leave petition, that is before the Supreme Court. So this is how any act is designed. So as a student of law, what we need to look at whenever any law comes, whether this framework, whether it fits into this framework. If this is not fitting into the framework, then we have to look at how that can be addressed. For example, I'll give an example. Transfer of Property Act. We have a Transfer of Property Act, correct? Now the Transfer of Property is an act to regulate the transfer of property between two or more interviable persons who are living. So that person can be artificial or judicial person, or it can be natural person or human being. So if there are two persons, the transaction between the two persons are getting regulated through what is the purpose? Now, where it is applicable? Applicable across India, because it is a central act. Now, who are the stakeholders? Actually between the two parties, that also. The obligations and duties are also cast on separate, different sections of the Transfer of Act as to how the transfer will be done, what is sale, agreement for sale, registration, immovable, movable, all those things are given. The compliance is also given. Compliance, when I say, if it is related to immovable property, naturally there has to be stamp duty paid, there has to be registered, it is more than 100 rupees, what are the documents to be registered, not to be, all those compliance are given there. Now the question comes, authority. Is there authority in that Transfer of Property Act? It is a very small act, but Transfer of Property Act is an act to regulate the transfer of property in India between two interviable persons or interpersons when they are living. So now, is there authority?
There is no.
Sir,
Sorry.
There is no
authority, quasi-judicial authority in Transfer of Property Act.
There is no authority.
According to my understanding.
There is authority or there is no authority?
There is no authority.
There is no authority which is specified in the Act. If there is no authority specified in the Act to regulate the the provisions of the law, naturally the courts in India. So that means the Civil Procedure Code will come into effect. That means we will have to go to the court. It can be. Then the question arises whether if he is a consumer. If he is a consumer, that means what we are talking about is the curative measure. So we wanted an authority to address our grievances which are there cast as obligations in the Act, which are cast as the requirement under the law, correct? If certain provisions are not done, then there has to be an authority to regulate it, but there is no authority to regulate these provisions. Naturally, the law of the land also provides the court. So therefore, we will go to the city civil court if it is a civil. If the provisions are such violated that they are also accounting to a criminal conduct, that is a fraud or cheating or something like that, then we will go to the criminal procedure code. If he is a consumer who is buying a property from a developer and he is considered to be a consumer, then we also have a concurrent remedy to go to the Consumer Protection Act. They are all curative measures. So the not necessarily that every law which has, that is what I want to point out, that every law which is designed need to have the authority. In the place of the authority is not there, then we will go to the civil procedure code or criminal procedure code or other curative measures which are given to one of the stakeholders in the other things. Are you with me?
Yes.
Similarly, now the moment authority is given, then the appeal is also mentioned in those respective legislation where I am saying civil or criminal procedure code. So appeal and writ petition, other things follow. Now, as we said, redressal of complaints, that is where we have come now. Authority is not there, but authority is the ordinary court of law. So this is how each act need to be looked into. Okay, whenever we are looking at any act, this is the framework in which if you start working, tomorrow if you pick up any law, just put these 5-6 pages. So make the heading of the pages, this is the objectives. What is the objective? 1, 2, 3, 4. And within 10 minutes you will be studying the law. Second, applicable jurisdiction, which is that? Whether it is for India, whether it is for local authority, whether it is for, then stakeholders. Look at the stakeholders whom it is applicable, and then look at the obligations. Each of the stakeholder, what is the the transactions or the obligations that is cast. Then the compliance need to be done. Is there any compliance to be done? Who is the authority? And then of course redressal of the grievances or if the law is not followed, where I can go and appear and then do the needful. This is how we can look at. Today we are looking at what is known as the MCS Act, Maharashtra Co-operative Societies Act. Now, what is the objectives of the Maharashtra Co-operative Societies Act? What is the objectives? The basic objective, yes? To regulate registration and management of a legal entity under the provisions of Maharashtra Co-operative Societies Act. So that means the purpose is to register a collective or what we call as joint ownership enterprise promoted by the members, having the cooperative principles, that is one person, one vote, that is equality of, having a democratic principles, that means each person will represent. So these are certain principles of cooperatives. There are 7 principles of cooperatives. So all those 7 principles of cooperatives, under that if a legal entity has to be formed, that will be done under the Maharashtra Co-operative Societies Act. Registration, regulating and of course management of the cooperative societies now in the state of Maharashtra. The objectives is in the state of Maharashtra. Now question comes, who are the stakeholders? In the MCS Act, who are the stakeholders? Naturally, the person who joins the society, that is member. Second, the members elect the managing committee to look after the day-to-day and management of the affairs, that is called either managing committee or the board of directors. So that is the next stakeholder. Next comes, because there is a member, then the managing committee, naturally comes somebody has to register this. The authority who has to register is the registrar. Now once the registrar is given, authority is given, the registrar's jurisdiction also has to be defined. Each registrar has his own jurisdiction. It is not that he can do the other place. So who defines that jurisdiction? Of course, is it given in the act? That means the government will determine who will be the having which jurisdiction. Then what are the provisions of the sections which those authority can implement? It is not that every section can be implemented by everybody. So there is delegation of power. That is called, the authorities are set up. Once the authority is set up, there is a delegation of power. Now, each stakeholder we have just now defined that there is somebody called the member. Then we have managing committee. Then we have the what is known as the registrar. Now if these three people are there, then they are also having certain obligations, what the members can do, what members cannot do, what managing committee can do, what managing committee cannot do, what the registrar can do, what registrar cannot do. Now all these obligations are under the different provisions of the Act is given. So if some of the stakeholder or any one of the stakeholders have not complied with what is required or what are the compliance they have to do, that also we will look into, what are the compliance they have to do. Now once we understand that compliance, now who will do that compliance? Of course the stakeholders will do. If they don't know, they do not carry out their obligations or the compliance, naturally we can address to the authority. Now who is the authority here? Of course we have a regulator, that is called authority within the Act. So there is something called the authority within the Act, there is something called authority outside the Act. Now outside the Act is given in the Constitution of India, okay, or other peripheral law. That I am not getting into that, but naturally what is given in the Act need to be looked into first, and that is the first redressal that need to be done. If I have certain authority which is set up in the Act itself, then I have to go to that authority only. I cannot go outside and look at that. So there is something called bar of jurisdiction. So if there is some regulations which are made, then naturally we have to exhaust our all the grievances or redressal within that Act, and after exhausting that we can go to High Court and Supreme Court. Now just to give you an example, there is a bar of jurisdiction. Bar of jurisdiction in the MCS Act, there is a bar of jurisdiction as far as civil court is concerned. I will not be able to go to civil court because there is a bar of jurisdiction in the Co-operative Act. Why? Because when there is a special act to regulate the registration, management and compliances of the provisions under the MCS Act, you have no business to go outside and seek the redressal. But there can be certain things which are also provisions of the Act, but it also affects something else. In that case it may be related to transfer of property, it may be related to property or other things, or the transaction that I am entering into an outsider, then of course I can look at the other law. And of course there is something called Consumer Protection Act which gives us an additional remedy. So one has to look at, is there any additional remedy which is available in the other concurrent legislation? If there is some concurrent legislation where you get a concurrent remedy, then of course you can go to that as an additional remedy, but not as an exclusive remedy. But you have the first remedy within the Act. Now as I said, the registrar is an authority, then of course what is his authority, what is his role, everything is defined in the Act. Then of course there is an appeal, there is a revision. Then in the MCS Act, not only that we have a regulator. If you look at any law, always there is not only a regulator, that is called authority, to take care of the things available. There is something which sometimes, I am not saying every time, but sometimes that law also gives you the additional remedies for additional sections. So that means what we normally call it as a tribunal. So prior to some amendments, some took place maybe in 1970 or 71, I am not very sure. In the MCS Act, earlier the cooperative court was called as a tribunal. It was called as a cooperative tribunal. So there was a cooperative registrar and cooperative tribunal. But later on, that cooperative tribunal was converted into cooperative court. So that that legislation that got amended. So we have a cooperative court now. Now certain provisions or the obligations that cannot go before the authority. So when there are two authorities or the two what I could say, the authorities who are monitoring and taking care of the provisions in the Act, then we have to have a clear-cut distinction as to what is coming before the authority and what is coming before the court or additional things. So the distinction is most important, and that is where practically the advocates or the law student need to look into. Just to give you an example, now there may be a dispute between a member and the managing committee member. Now will this go before the registrar or it will go before the cooperative court? Now that need to be applied, and at any time, anywhere, when we go for redressal of any grievances, the first and foremost objection that the respondent always take is that the grievances is not maintainable, saying that the authority before whom the petition is made is not having the jurisdiction. So there is a lack of jurisdiction. That is the first defense that anybody take, and based on that they move a miscellaneous application. They try to address the authority saying that you do not have the jurisdiction, so decide whether you have a jurisdiction or not. So the moment you decide that you have a jurisdiction or not, then I will be able to appeal that order before the, either in the High Court saying that it is a writ petition, though without the jurisdiction he has gone beyond his jurisdiction, or under any other applicable appeal or revision provisions. So the first and foremost thing, always the jurisdiction of the authority, that is always challenged. So therefore, when there are two authorities given in any statute, one has to look at what is the authority of one authority and another, what is the distinction. There may be certain concurrent, there may be overlapping, but even if there are overlapping, as a student of law, as a consultant, we need to be having more clarity within our mind. That is more important. Then of course, as I said, there is a writ petition, and that is how even the Cooperative Act is being designed. Now, when I look at any law, or as I said, any provisions of the law, the first and foremost thing, as I said, what is the purpose? Okay. Now, having decided the purpose, we will just look at the MCS Act. This is related to chapter number 13B. This next time Kiran will take it, because she has already given a lecture on this. So next time she will take. Today I will just take the overview of the Act. So Naresh, now tell me, as far as MCS Act is concerned, what are the things that we can look at? In the MCS Act, there are two authorities. One we have a registrar, So one is we have a registrar of cooperative societies. So let us look at the authorities under the MCS Act. Yeah, one is the registrar of cooperative societies. So that means we are talking about registrar. Now in the registrar also we have two different or three different layers, or maybe we can call it as a 4 different layers. Now, or maybe we can call it as 5 different layers. Now what are the 5 different layers as far as registrar is concerned? So let us look at the registrar, correct? Registrar, I said there are 5 different layers. Now can you tell me which are the 5 different layers? I am talking about 5 different layers. In the registrar we have 5 different layers, or that is called different, they are all registrars. Hierarchy, yes, you are right. So I can call it as a hierarchy. What are the 5 different hierarchies in the registrar? Okay, we can call it as a deputy registrar or assistant registrar. So depending on the volume of the business in that jurisdiction, so either we have in Maharashtra, we have assistant registrar or deputy registrar. They are at the taluka head. So each taluka, in Mumbai of course we have ward wise, but other than Mumbai we have registrars at the taluka level. So if we have about 330 talukas in Maharashtra, we have 330 deputy registrar and assistant registrar, one of them. So in Mumbai we have 24 wards. Each ward there is one assistant registrar or the deputy registrar. Okay. So this is one. Secondly, so then above taluka we have district deputy registrar, correct? DDR, district deputy registrar. Any doubt in this? So we have district deputy registrar. That means, again as we said, there is a registrar in the taluka level, then in taluka is further expanded into known as DDR. Now DDR is for the district. Now in the district, now in Maharashtra we may be having 36 districts, so every district there is a district registrar. Now the third is, after this registrar, then we have divisional joint registrar. So DJR. Now Maharashtra is divided, as far as cooperative department is concerned, into 9 divisions. So we have divisional joint registrar. Just to give you an example, as far as Mumbai is concerned, we have, let us assume, K East, K West. So we have K East ward, that is one registrar or deputy registrar. K West is another registrar. Okay. So now Mumbai as such is divided into DDR1, DDR2, DDR3, DDR4. Now though there are 2 revenue districts, Mumbai we have only 2 revenue districts. One is Mumbai city, another is suburban district. Revenue districts are 2. Okay. And 2 districts are converted into, or for DDR we have a DJR Mumbai, who is sitting at Malhotra House. Now DDR1 is South Mumbai, DDR2 is Eastern Suburb, DDR3 is from Bandra to Goregaon, Jogeshwari. Bandra to Jogeshwari. Bandra to Jogeshwari is DDR3, and Goregaon to Dahisar is DDR4. Okay. Now after the DDR we have divisional joint. So like this we have Konkan division, DGR Konkan, divisional joint registrar Konkan. Now Konkan means Thana, Palghar, Raigad, Sindhudurg, that is Konkan belt. Then we have Nasik division. Then we have Pune division. Pune means Pune, Satara, all this. And then we have Kolhapur division, Nagpur division. So this way the cooperative department is divided into 9 divisions. So above the DDR we have DJR. Now the 4th layer is additional registrar. Additional registrar. Have you heard about this word? Additional registrar? So this additional registrar is sitting at Pune, and he has a division, or rather society wise, below the Commissioner of Cooperation and the Registrar of Cooperative Society. There is an additional registrar who may be for, let us say, banking, one additional registrar, cooperative housing society, one divisional joint registrar, then credit society, one divisional joint registrar, so sugar factory. So like this, different types of society. Okay. So for banking, one additional registrar, taking care of the, so in the commissioner office there are, below him there are additional registrar. They are above the joint registrar. So the next promotion that comes, hierarchy, is the additional registrar. Maybe we are not always in touch with them, but there are additional registrar who assist the registrar. So actual registrar is Registrar of Cooperative Society and Commissioner for Cooperation. So this is at the state level. Additional registrar also is a state level, but additional registrar for a different, for that particular type of societies, and registrar and commissioner for cooperatives. Okay. So this is now the question arises, there are different sections which will go to the different people. Try to understand. So the authority to deal with different sections which goes to the different registrar. Who defines this? Of course, this delegation of power to this type of hierarchy registrar is given by the government. Now who is the government? Naturally, government for us means not the minister. Government for means our cooperative secretary. So cooperative secretary, under the signature or the authority of the governor, he issues the GR, and of course before issuing the GR it will be taken the cognizance of the commissioner, this minister. But actually cooperative secretary issues the delegations of power GR in the name of governor of the state. So in the governor of state he issues the notification, that is called notification. This is called government resolution. It is also called government resolution GR, or it is also known as notifications. So these notifications are issued by the cooperative secretary. So that is his role. Now above cooperative secretary we have cooperative minister, that is about the politically elected representatives. Now how you will come to know, from where you will come to know, that is very important. From where you will come to know which matter I have to take to assistant registrar or deputy registrar, which matter I have to take to DDR, which matter I have to take to DJR, which matter I have to take to additional registrar, which I have to take to the commissioner or the registrar of cooperative society. So from where you will get?
Particular section.
Now if you go to the sections, you go through all the sections, I will show you, it says registrar. Everywhere what it says is registrar. Nowhere it says in the act. Okay. You go through any sections of the act, now we have nearly 168 sections I suppose. So you go through the sections of the act, you can take up the act. Now you go through these sections, Maharashtra Cooperative Society Act. Now whatever the sections you pick up, everywhere it only says the 168 sections are there. Now if you look at 168 sections, everywhere it says registrar. You can report to the registrar. Now who is the registrar? What I am saying is, the word which says,
Generally.
not generally, I am just saying the word used in the act is registrar. Now section 91 says it will be referred to cooperative code. I am not on that. What I am saying is, whenever the section says that in the cooperative act, it says registrar. You will submit the document to the registrar. If something goes, membership is not given, go to the registrar. Society registration, go to the registrar. The registrar shall have the authority to, if the auditor is not appointed, the registrar shall appoint the auditor. Are you with me?
Yes.
Section 81 says that in the general body the auditor should be appointed, and within 30 days the consent of the auditor has to be taken. It should be submitted to the registrar. Now appointment of the auditor has to be submitted to the registrar. Now my question is, if the appointment of the registrar's auditor has to be reported to the registrar, who is the registrar? Am I supposed to give it to the deputy registrar? Am I supposed to give it to the DDR? Am I supposed to give it to DGR, additional registrar, or the commissioner? Whom I should give? From where we come to know. And that is where I am saying the very purpose of challenging the jurisdiction. Yes, now we were on the subject कि jurisdiction is very important. So if we have to look at the jurisdiction, so how you look at the jurisdiction? I have just said under section 81, appointment of auditor has to be submitted to the registrar of cooperative societies. Clear? Now who is that registrar? From where you get this? Because when you want to challenge somebody, let us say we are on the defense side, okay, respondent. Now if I have to challenge that, then I have to know the section under which I am challenging that. I have to tell him that you don't have a jurisdiction. So who is that? From where we come to know? Naturally I said there is a delegation of power. Now the delegations of power is with whom? With the government. When I say government, that is governor. Of course in the name of governor, secretary issues the authorities. So that means section 3 of the act, MCS Act, if you look at, so it is given the government has the jurisdiction to issue the directions and rather delegation of power, and that delegation of power through the notification it comes. So you have to look at the, whenever you want to challenge the authority, whether that section can be dealt by that person or not. Section 81, yes, it is with the DDR. Society registration is with the assistant registrar, again depending on the jurisdiction. If it is a district jurisdiction, then it will be with the DDR. If it is with the division, it will be division joint registrar. So many things need to be looked into. Okay? So now section 3 of the act gives us the delegation of power, and where is that delegation of power, how this can be identified, I will give you little later, before we end. So coming to the point, now cooperative act or any act, then when we look at, the most important thing need to be is how many chapters are there. So in thus we have nearly 14 chapters. Okay. So the first and foremost thing that I look at, or any act you need to look at, as I already told you, what are the compliances, what is to be done, or the authority, stakeholder. From there you try to bifurcate the sections, and the moment you bifurcate the sections, now look at the MCS Act. MCS Act is divided into 14 chapters. Now when we look at the 14 chapters, now basically in any chapter, always we have, or any act we have preliminary. Chapter number 1 is always preliminary. Now what is that preliminary all about? Preliminary is what is the name of the act, whom it is applicable, that means jurisdiction, when it comes effective, what is the date of effect, and the next comes is the definitions. What are the various definitions used? If you look at section 1 and section 2 of the MCS Act, that is related to the preliminary. So this is how a particular act is looked at. So now many act, it says it commences from the date of its publication. That means effective from the date of effect of that act is from the date of notified. Now that particular section also need to be notified. The law does not become effective unless until it is notified. The assembly or the parliament, as the case may be, pass the act. The act may be passed, it may be gazetted, it may be published, everything, but not necessarily that particular act becomes effective on the day it becomes notified. It is not necessarily that the day it is published or it is accepted by the president or the governor of the state, not necessarily. So there can be a provision saying that this becomes effective from the date as may be notified by the government, from that date. So that means for the implementation of the act, try to understand, because we are all on the jurisdiction, we are all on the point when this law has become effective. What is the date of implementation? Just to give an example, we have the what is known as RERA. RERA is published on 26th March 2016. Okay, but 2016, but it is effective from 1st May 2017, implemented from 1st May 2017. Now whether it is mentioned in the act, RERA Act, no. What it mentioned is it is effective from the day as may be notified by the government, as may be notified by the appropriate government. So that means it has to be notified by the government. Some law may be implemented the day it is published, effective from the day it is published. If you look at the amendment to the act, it says it is implemented with immediate effect. Immediate effect means it is implemented on the day it is published. So this need to be looked into. Secondly, very importantly, the law, as I said, is become effective or applicable to certain jurisdiction also. The law need not be applicable across Maharashtra. The law need not be applicable to across Maharashtra. I am just giving an example. Maharashtra Ownership Flat Act 1963. When that law came into effect in the year 1963, implemented from the year 1964, after the notification of the rules, it was not applicable across Maharashtra. Though the word was Maharashtra Ownership Flat Act, it was applicable only to certain regions. That is only for Mumbai, maybe later on it was Pune, Nasik, Nagpur, certain regions it was applicable. Thereafter it was getting applicable for further time and for further area. Then in the year 2012, it was made applicable across Maharashtra. So till such time, every region was getting notified. So that means the law may be applicable or implemented by the state of Maharashtra, not necessarily that is applicable across. So therefore, when I am looking at the jurisdiction, somebody, let us say in the year 1980, I am just giving, so somebody at Ahmedabad, Aurangabad, so if he goes and says MOFA and goes for something, then one can say that MOFA is not applicable to Aurangabad, because there is no, this is applicable only to Mumbai and maybe Thane and other parts, but not to Aurangabad, because that is not notified. That law is not applicable. So the law may be made applicable from a particular date, and it may be made applicable to a particular jurisdiction. So when I look at the applicability of the law, that also need to be looked into. Am I clear on this?
Yes.
Now, so this is how the preliminary, if you see the MCS Act. Second, we have a registration. But the very purpose of the Act is to register the cooperative society. So when we are saying cooperative societies, yes, cooperative societies can be registered. What type of cooperative societies? Who will register? All that is given. What are the conditions for registration? Everything you will look at chapter number 2. So that means if I have to give a consultancy to regarding a registration of a society, bifurcation of the society, amalgamation of the society, then I have to look at the registration chapter. So by going to the registration chapter, applicable provisions of the registration chapter, I will be able to look at it. Because what happens, there are many laws and 168 sections. So as you go on doing practice and as you go on understanding the provisions of the law, you will naturally realize where I need to put my concentration, focus. Focus, if it is related to the registration, I have to look at the focus of registration only. I don't have to look at anything else. Now, members, their rights, responsibility, liabilities is given in chapter number 3. So if related to any membership, admission of member, removal of the member, all that can be looked at chapter number 3. Then chapter number 4, we have incorporation, duties, privileges. What are the, how the society's privileges, what are the privileges of the society or that particular legal entity. Then about state aids, there may be certain aids given to societies by the state. Then property and funds of the society, how to regulate the funds and properties of the society because it is an individual identity or a different person. Then we have management of the society, how to manage the society, how to get the committees elected, general body, various things. Then audit, inquiry, inspection, because at the end of the day, the members will not have the direct access to the books of account. So therefore, there is something called an independent auditor who is appointed, and then inquiry can be done by the registrar and inspection, supervision. Then of course the next chapter comes is about the settlement of disputes. So here is the dispute settlement. Now there can be, as I said, there can be settlement of the dispute. That settlement of dispute is mentioned in the cooperative code as far as MCS Act is concerned. But there are certain grievances which are going to the registrar. Now if I am to look at, because we are more dealing with the litigations, so let us understand what is the major difference between a cooperative court and the registrar. Registrar always and handles related to the administrative aspect. Registrar is a regulator. Anything related to the administration and management of the society. Please understand, anything related to the administration and management, blindly you can say that it goes to the registrar. Now, what are the, just to give an example, what is related to the administration and management? Administration means keeping books of account is an administration, receiving the membership form, maintaining, issuing a share certificate, holding the general body meeting, carrying out the audit, compliance, submitting the returns. So audit rectification report, all these are related to the management, related to the administration, election. Are you with me?
Yes, sir.
Which means related to the administration, related to the management of the society, where the managing committee members are required to take care of those obligations and they are not doing. So go to the registrar. Now, any decisions or whether that is violations of certain sections, the decisions which are taken are contrary to the provisions of the Act, rules or bylaws, or contrary to the provisions of the government notification, any decisions which are taken are contrary to the provisions of the Act, that jurisdiction is with the court. Try to understand. any contrary to the provisions, what needs to be done is not done, go to the registrar. Something which requires to be done, not done, go to the registrar. That means related to the administration. This is a distinction. But if something related to the decision taken in the general body, decision taken in the managing committee, decisions which are not as per the act, that is what we want to say, it has been violated the provisions of the act, that means it requires lot of what is known as argument, counter argument. So in that case, that decisions will be with the cooperative court. There is a dispute related to the contravention of the act. Very thin margin, very thin distinction. Just to further elaborate, anything related to management, registration, amalgamation, administration is with the registrar. Anything related to the dispute related to the contravention of the act, provisions of the act, contravention to the bylaws, contravention to the contravention of any decisions are need to be whether that particular general body is a valid or general body or an invalid general body, whether the decision is a valid or invalid decision, who will decide? Cooperative court. So that is a difference. Second, yes, the registrar always has a direction. He can always, because registrar is a regulator. A regulator for whom? A regulator to take care of the management. He is like a charity commissioner administering the property there, charity commissioner. Here he is regulating the management, and the management is looked after by whom? Managing committee or board of directors. So the registrar can give the direction to the managing committee, again when he has to give. But can he give a direction to the member? And if the member does not, if you look at the provisions of the act, the registrar cannot give any direction to the member. So he does not have the hold on the member. Are you with me? Go through the act, other than of course recovery of dues, recovery of the dues which is there, because again it is the money that is to be recovered. So therefore it can be a direction to there under section 154B29 or 101. But other than that, if a member is misbehaving, can he be penalized? Can action be taken by the registrar against that member? The answer is no. Other than the recovery of dues, there are no other provisions which gives liberty or power to the registrar. But yes, cooperative court can give the direction to the member. So therefore any dispute between the member and the society, past member and the present member or the committee, everything goes to the cooperative court. So there is dispute in that, it is there. Then of course liquidation. If the society has been registered, it can be liquidated. Under which provisions of the act it can be liquidated, how it can be liquidated. Then insured cooperative bank, it is a type of society. Agriculture and rural multi-purpose development, it is a separate act. And then what are the offences and penalties? See, when we look at the as a practitioners, cooperative practitioners, we have to look at this chapter very carefully, because this is the chapter which will help us to book the managing committee. Because anything which is considered to be an offence, what is considered to be an offence? What is the penalty levied? And with whom we can make an application for the offence? All that can be looked into, and this chapter need to be looked into. Settlement of dispute is another chapter which looked into. Then of course registration of the society, membership, another chapter. Then of course another very important chapter is appeals, revision and review. There is a difference between appeals, review and revision. So again, which order can be appealed? Cooperative court order can be appealed under the Maharashtra Cooperative Appellate Court. Registrar's order can be appealed to the Divisional Joint Registrar. Divisional Joint Registrar order also can be appealed. So there are appeals. Which order can be appealed whom? That section need to be looked into very carefully. Then of course we have Maharashtra State Cooperative Council. It is an advisory board. That is chapter 13A. 13B, now we have the MCS Act for the applicable to cooperative society, which Kiran will take in the next session, and of course miscellaneous. So this is how totally we have chapters divided. If you look at that, Insured Cooperative Bank is one new chapter which was introduced. Then A and B, there are two more chapters which are introduced. So this is how three new chapters have been added, 13A and 13B. And if you go back, so there nothing is added. So whenever, if you look at any section, and if there is A, B or chapter A and B, you have to understand that this is an amendment. The law gets amended time to time. So if there is one section, let us say section 56, if there is section 56A, which means it is amended, just for the sake of understanding, because they don't want to renumber the sections they want to keep as it is. Amendment comes with the suffix. So this is how the MCS Act. So what are the things that we as a practitioner need to look into? First, yes, we need to concentrate on preliminary things. We need to look at the registration also, because registration, amalgamation are some of the area of practice. Membership is another thing which need to be looked into. Then of course funds, properties, management is another thing, audit, inspection. So that means almost all the chapters are that way very important. And then of course dispute, liquidation also equally important. Then we have offences, review. These are the few chapters which we need to concentrate. And MCS Act as applicable to Maharashtra Cooperative Societies Act, which Kiran will take in the next session. So 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. So where are 3 people? Missing 16, 17 people were supposed to come. ठीक है. Now, अभी तक जितने भी मैंने explain किया, whatever I have explained so far, okay, in this, any queries, any thought process which is coming in your mind that I have missed in the area of practice? Yeah, Partha? Or you need more clarity? See, I am just now only on a topic, jurisdiction. How to decide a jurisdiction? And I am on the topic as to overview of the Act from the practice angle, which are the chapter that you need to look into. And I have also given you a framework as to how one law has to be analyzed. So the next question arises, if a customer comes. So I'm going to deal with each chapters subsequently, because each chapter will take one session. It is not that the chapter will be dealt with within a day. Today I have just said, let me give an overview and try to have a distinction between various authorities, between the jurisdiction, between how to read the Act, and especially MCS Act, which are the important chapters. So if a particular client comes to us, so what is that we normally ask from the client? Naturally we ask, what is your grievances? What do you want from us, isn't it? He comes, he explains this, then I will say, what are you looking for? What is your grievances? Then immediately I need to apply my mind as to which law, under which law I need to take him, which is the provisions of the Act under which. Then we will also normally tell them that, okay, let us issue a legal notice. Why legal notice? The legal notice is the one which we issue And whenever we issue a legal notice, we need to address the provisions of a particular section of the Act which has been violated. If we are giving them any what is known as any legal notice without referring to the particular sections of the Act which he has contravened, that means that legal notice has no validity. So therefore, once we are issuing legal notice, at the end also we say our client reserves the right to proceed criminally, civil against you, to proceed under civil procedure code or civil or criminal proceedings. Okay, he reserves the right to initiate civil and criminal proceedings. Now civil proceedings, of course, under the relevant Act, even the criminal proceedings also comes under the IPC, Indian Penal Code. So now coming to the point. Okay, so the client has come, you have analyzed, then you have to look at under MCS Act which is the authority that we need to address our grievances. Then accordingly we have to prepare a complaint. And when I look at the Act, the second thing which I need to look into, naturally, the procedural aspect. See, there are two important things. Now whether that procedure is being followed or not, because once I am going in the appeal, first thing is the authority jurisdiction, so that I am challenging, I am countering, I am trying to satisfy myself, and relevant provisions of the Act also I look at. Secondly, I also look at the what is known as the procedure, whether that particular person has followed the required procedure. Where is this procedure is laid down? Procedure is given in the rules. Now the procedure and the forms are given in the rules. So whether that particular provisions of the Act has been properly implemented. Implementing agency is a registrar, let us say, in the Co-operative Act. So the registrar, whether he has taken up the proper procedure. So that also need to be looked into. The next is, in addition to the procedure that is given in the rules, we have some notifications, circulars, GR. Now we need to look at the GR also into two different types of provisions. One, the GR which is given under the specific power given under the Act. That means GR cannot be issued just like that. Government can come out with the GR, government resolution, if they are given powers under that section. And that power is again given to the different authorities. Try to understand that GR which is issued, also issued under the powers given under that section, and that section gives the power to only one person. Let us say here in the MCS Act, the GR can be issued by the government. Government means cooperative secretary. GR also can be issued by the cooperative commissioner. Are you with me? GR also can be issued by the commissioner. So certain provisions, certain sections gives the power to the registrar, that is a cooperative commissioner, to come out with the notification or circular. Now that circular also can be more of an administrative circular. It can be a circular under the provisions of the Act, means to implement the Act, to clarify the or delegations of power, or to clarify their powers, or the need to be done procedure. So there are various type of circulars which also need to be looked into. So again, when I am saying that GR is issued, so again that particular GR is issued within his power or not also can be looked into. So whenever a GR, somebody is relying on the GR, as a law student or as a practitioner, what we need to look at it, in that GR under which provisions of that section of the Act or the rules that GR has been issued. So many places I have seen that GR is issued by the registrar, that is a commissioner or government, without saying exercising under which sections of the Act they have issued that GR. They are not specified, and those GRs have been always set aside by the Honorable High Court, saying that there has to be specific mention as to which provisions of the Act they have invoked. So issuing of a GR also requires the power. ठीक है? So this is how the Act has been coined. Now we have another 20-25 minutes, so you can throw the questions, and for today we can conclude, and next time what we will do is we will get into the membership. Now next time whenever we have the session, we will talk about who can be a member. Second, once I said who can be a member, then I am going to say that how the member can be removed. If the membership is not granted, then who is the authority where I can make appeal, and then where the revision lies or the appeal lies, and then we will go to the writ petition and all hierarchy related to the membership. So next time on the membership, because there are two types of members, one is a deemed member, one is membership granted, then so many issues related to the membership we will deal next time. Registration of society also will deal separately, but next time we will deal with the membership. And then of course he has a request for recovery of dues, cooperative court matters, then enquiries, rectification. So many things are there in the Cooperative Act, but maybe over a period of next 7-8 sessions we may be able to thoroughly go through the MCS Act. Now chapter number 1, we have short title, extent and commencement, and definitions. These are the two sections in the preliminary. Then definitions, we have various sections: bonus, bylaws, what is bylaws, what is bonus, what is central bank, cooperative bank, appellate court, cooperative year, dividend, member. Member means a person joining in an application for registration of cooperative society which is subsequently registered, or a person duly admitted to a membership of a society after registration and includes a nominal, associate, and now of course for housing society, joint member. So the members definition is also given: associate member, nominal member, officer, who is the officer. See, these are all very important things. Why? Because in different sections these words are used. So therefore one has to look at recovery officer, sale officer. There is a difference between the recovery officer and the sale officer. So the registration, see, look at this: registrar and his subordinates. Now who is registrar and his subordinates is given in section 3, and who does by way of notification. Government has power to designate registrar, his jurisdiction, all this is given there. So just to take it, so section 4, society which may be registered, objectives, all this is given. Now see section 3, how it reads: registrar, section 3, state government appoints the registrar of a cooperative society for the state and also appoints a person to assist him for the local areas or the state So to assist him in the state, who is that additional registrar? So local area, we have district, we have taluka, we have ward, we have division, as may be specified and conferred by specific order on any such powers of the RCS. So a specific order given by the government. State government appoints. It is who appoints? State government. And state government appoints the registrar, that is a cooperative commissioner, we call it a RCS or the commissioner for cooperation for the state, and also appoints a person to assist him in local area, again by the state government or the state as may be, for the local area or for the entire state, appointed by the state government, specified and confirmed by specific order. There is going to be a specific order, that is notification, or such powers of the on any such powers of the registrar. That means any of the registrar's power can be delegated to subordinates. Who has to register the society? Registrar. But Registrar has to register, but he cannot register entire state. So the government delegates his power of registration to local authority, to the local registrar, and that is how things are looked into. So therefore, now the question arises, I was saying that notification need to be looked into, correct? So this is very important for us to go through the notification related to the jurisdiction. Okay. So section 3 gives the power to the state government to issue the GR, empowering the registrar, joint registrar or additional registrar or the DDR or to the what is known as to the commissioner himself. So that delegation of power, yes. See, this is issued by the Cooperation, Marketing and Textile Department. This is Cooperation, Textile and Marketing. All these three are one department. So therefore they are department, Mantralaya Annexure Building. So this is the order number so and so. This is the order dated 5th January 2012. Okay. Now, this order is issued under which? So there is a order number which is the date issued, and it is issued under Maharashtra Co-operative Societies Act. So every act, the government has the power. Under the different act, the government has the power to appoint or issue the, give the delegations. So this is under the MCS Act. See, look at the wording. In exercise of the powers conferred by section 3. So that means any notification when you look at or order you look at, it has to be in exercise of the powers conferred by section 3 of the Maharashtra Co-operative Society Act. The government of Maharashtra hereby confers on all the divisional joint registrar of cooperative societies and the district registrar of cooperative in the state. So it is divisional joint registrar and the district deputy registrar in the state. The powers of the registrar under section 81(6). Under section 81(6). 81(6) is related to, 81 is related to audit. So section 81(6) is related to the re-audit of the act to be exercised by them within the area of their respective local jurisdiction. This is one notification. So 81(6) ka the power is given to whom? Divisional joint registrar and the district deputy registrar for their respective jurisdiction. Now respective jurisdiction, local jurisdiction किसने दिया? उनका jurisdiction क्या है? That is also separately defined under by different notification. So that means by looking at one notification you will not know. So we will come to the next, cooperative courts area of jurisdiction. So that means even the cooperative courts, there is cooperative court number 1, 2, 3, 4, correct? Then there is a cooperative court in Mumbai, we have 4. Barabar na? Then every district there is one cooperative court. So maybe Thana cooperative court, Palghar cooperative court, then today there is a Palghar district but there is no Palghar court. So it goes to the Thana. Then we have Aurangabad, this, that, Nagpur. So every district wise there is a cooperative court. Now, of course, Maharashtra Co-operative Society, how the jurisdiction, headquarters, etc. See, in exercise of the powers conferred under section 1, subsection 1 and subsection 3 of section 91A. So 91A gives the power to the state government to notify a court for their jurisdiction, for respective jurisdiction. So it is under 91A. Section 91 is related to cooperative court. So 91A is an added section, amended section of the MCS Act, and in supersession, what is the meaning of this? Can anyone tell me? Maharashtra 26 of 1961. ये क्या होता है? See what happens. Mr. Advocate Naresh Pai is right. See what happens. Every year, whenever the legislation from January onwards, because if you look at appeal number, complaint number, everything is given of the year, registration number. So what happens is, whenever this comes, Maharashtra 26th Act of 1961. That means in the year 1961, 24th Act, 24th Act of 1961 passed by the Maharashtra government. 23rd दूसरा होगा, 22nd दूसरा होगा. So every act, it gives a serial number of the act passed in that year. This is the serial number of the act passed in that act year. ठीक है?
Any of the act.
Any of the act मतलब?
मतलब this 24th of 1961 is what for MCS Act.
हाँ.
So the 23rd may be for any other act.
State Act.
It may be स्टैम्प एक्ट हो सकता है.
State related.
I don't know because वो क्या होता है, वो साल में कितना एक्ट पास हुआ. So in the sequence, when it comes to the legislation, there has to be some check and balance. Act ऐसे ही नहीं होता है ना. So there has to be some sequence which is given. So therefore, this is the 24th Act passed in the year 1961. Okay, because one has to look at, and in the supersession means overriding of all the existing notifications so far as they relate to the jurisdiction of the existing cooperative courts, the government of Maharashtra hereby with effect from the date. अभी ये आप देखेंगे ना, हर जगह में यही आएगा. अभी ऊपर नहीं किया होगा उसने, हाँ ऊपर भी है देखो. तो this is of 24th Act of 1961 is cooperative act. Okay. Now and in supervision notification as relate to the jurisdiction of existing cooperative court. हर एक cooperative court को भी jurisdiction दिया जाता है. As I said, see in Maharashtra, Mumbai we have 4 cooperative courts. ना? So you have to look at, suppose मेरा बोरवेली का है, तो that will go in, let us say cooperative court 4. If it is in, I am not aware actually jurisdiction, you will have to look at it. So समझ में आएगा कि कौन सा कोर्ट में जाएगा. The government of Maharashtra hereby with effect from the date of publication. Now this is effective from the date of publication of in the official gazette. जिस दिन official gazette में आ गया 27 April 2012, that means it is effective from that date. Constitutes a cooperative court specified in column 2 of the schedule appended hereto for the adjudication of disputes referred to them under section 91 or section 101 or other provisions of the said act. So whatever cooperative court का jurisdiction है, that is given in column number 2. Specify that each of the said cooperative court shall have a jurisdiction over the area mentioned against in column number 3. Column number 3 में उनका jurisdiction दिया है of the said schedule and shall have its respective headquarters at the place mentioned against in column number 4. Where is the headquarters? Where is, so now let us look at this. So this is a schedule given. So serial number, name of the court, that is Wardha. Let us say this is a new court they have opened at Wardha. Now area of jurisdiction Wardha district. Headquarters will be in the Wardha. This is a cooperative court in Kalyan. What is the jurisdiction? Kalyan, Bhiwandi, Ulhasnagar, Amarnath, Shahpur, Murdaबाद, वाड़ा, ये तालुका के लिए, ये तालुका के लिए आप ये कोर्ट में जाओ. You cannot go to any other court. You cannot go to Wardha court. You cannot go to Nipan. सब cooperative court ऐसा नहीं. ठीक है? And Kalyan is the headquarter. Though these are the areas which are covered, but the headquarter is Kalyan. Then they may have a camp office here or they may have a another court here, but headquarter is at Kalyan. तो थाना में मतलब कल्याण के लिए भी एक नया कोर्ट ओपन हो चुका है. निपाड, योला एंड चांदवड तालुका कोऑपरेटिव कोर्ट गडिंगलज, सिंधुदुर्ग डिस्ट्रिक्ट तालुकास ऑफ गडिंगलज, आजारा, चंदागढ़, बुदरगढ़ in district Kolhapur. District Kolhapur के लिए one more court has been opened. Is it clear now? So this is how you will have to look at the jurisdiction, and whenever any petition is made, whether it has been filed in the proper court, not court, whether they have the jurisdiction or don't have the jurisdiction. So this is how you can look at this. Now appointment of district deputy registrar, their jurisdiction powers, etc. See, now on 11 September 2012, look at it. In the exercise of the powers confirmed by section 3 of the Maharashtra Cooperative Society Act, serial number 24 of 1961 Act, government has created 7 new posts as district deputy registrar. So 7 नया post create किया. For whom? Cooperative Societies Mumbai 4. 11 September 2012 से DDR 4 आ गया. Otherwise DDR 3 तक ही था. DDR 4 is a new district created in the year 2012. District Deputy Registrar, Cooperative Society Pune Rural, Deputy Registrar भी किया, Cooperative Societies R South Ward, that means पहला सिर्फ R Ward था, now it has become R South Ward. डोंबिवली के लिए अलग किया, पुणे डिस्ट्रिक्ट 5 सिटी 5 किया. Okay, this is how various registers posts have been created. Now look at the powers. Why GR number so and so 5th May 2011, hence in partial modification of the areas of jurisdiction and powers delegated by the powers delegated under section 3, okay, of the earlier notification. तो पहला notification था 1993. So 7th August 1993 is the original notification for delegation of power. That one has to look at it. इसको सब compile करके रखो. 7th August 1993 का कौन सा notification है? GR dated 13th October next notification आया. Okay, like this there are so many notifications. 5th January 2012. Okay. Hence in partial modification ये area notification को modify करते हुए नया GR निकला है. ठीक है. Appoints the officers specified in column for the schedule here to as the assist the registrar in the area specified in column 3 thereof. That means to assist the registrar means what? Commissioner. This is issued under section 3 of the section. Okay. Now district deputy registrar 3 उसका modify किया area. तो now his area is Greater Mumbai Municipal Corporation, H West Suburban Area, H East, H West, K East, K West. Society is within the operation of extending Greater Mumbai. मतलब ये district deputy registrar के पास what is available only this area. He can have a monitoring supervision. District with the area of operation extending over Greater Mumbai Municipal Corporation registered office which is located in the jurisdiction including society specified under section 73G and notified under section 73 IC of the Act. Government order 13th October 1993. ठीक है? This is about the area. Now, all powers of the registrar under the Act and the rules not being powers under. Look at this. ये जो DDR को है ना सब power दिया गया. But he does not have the power under these sections. So, section 9 subsection 4 is regarding registration of a society. Okay. Now, section 12 is something related to the membership and others, this one. So, these are the sections under which he does not have the power. Let us say section 152 is about the appeal. Appeal उसके पास नहीं है. 158 is related to the offences. That is not with the DDR. तो फिर किसके पास है? वो DGR के पास है. So what is not given power? So therefore, if somebody applies under section 148 offences with the deputy registrar or DDR, whether he has a jurisdiction, the answer is no. So you have to attach this notification and you have to tell that you don't have the power. Then immediately he will dismiss the complaint. तो इस तरह का jurisdiction is very important and these are the rules which are not to be done by this. So ये section को notification को आप बराबर पढ़ लेना. Okay. Same way district deputy registrar 4 ये 3 था 4 को भी वही similar same repeated but area बदल गया इधर. That is P South, P North, ठीक है, R South, R North wards. Now Deputy Registrar R North, उसका एरिया क्या? ग्रेटर मुंबई, R Central and R North वार्ड, उसी एरिया का वो कर सकता है. Now all powers of the registrar not being the powers under section 9 subsection 4 12 3 extension 2 to subsection 3, these are the powers he does not have. Who does not have? Deputy registrar does not have all these powers. तो ये सब उसको these powers he does not have. but other than that he has. So this is how you have to look at registrar. So I am only on section 1, 2 and 3. So 1 and 2 and 3, today let us look at the role of registrar. Now there are various sections, and every section the word used is registrar, but whether that delegation has been given to him or not, you have to look at. So the role of registrar, 1, look at this, section 6, to fix the higher number of persons more than 10 for registration of society. That means section 6 is talking about condition for registration of a society. Now who has the power to decide how many members has to be there? The Act says, earlier it was, even today it is minimum 10 members or such higher numbers as may be notified by the registrar. As notified by the registrar. That means who has the power under the Act to notify the number of members required to register the society? Registrar. Now who is this registrar? As per the delegation. Correct? So if there is it is not delegated to anybody, it is not delegated to anybody, then it remains with the commissioner, Registrar of Cooperative Society of the state. So section 6 is not delegated to anybody. So that means it is retained with the, all the powers of the Act is with the registrar. Okay? So delegation, the government says all the powers of the state is with the cooperative commissioner and the Registrar of Cooperative Society. So section 6 is not delegated to anybody. So that means it is with the cooperative commissioner. Now minimum is prescribed in the Act. Now for the housing society minimum is 5. For other society minimum is 10. But more than 10 also is required in certain type of societies. That will be notified by the commissioner. Now which is the society? Just to give a understand example, let us say we want to form a credit society. We want to form a credit society. Then I have to look at how many minimum members are required. Correct? The Act says 10. With 10 members can I go to the registration of a credit society? The answer is no. Then per taluka, if I want to go with the taluka wise, then minimum 300 or 500 members are required. So much minimum capital is required. All this is given by the Cooperative Commissioner's circular. And therefore, whenever the society registration comes, they refer to the circular issued by the Cooperative Commissioner. So, Commissioner has prescribed different members for different area of society and for different type of society. He has already prescribed. Wherever it is not prescribed, which means it is 10. Okay? Now, registrar to section 9. To register a cooperative society as well as its bylaws. Who registers it? Registrar. Now, who is the registrar? Suppose I have got a society in K East. K East means Andheri. मान लो. So, who will register the society?
Under whose jurisdiction?
Under whose jurisdiction? That is of the ward. ठीक है. Now, I have got a society in Andheri. Okay, I have got a MahaSeWA Metropolitan Cooperative Credit Society in Andheri. But the jurisdiction of that is the entire district. Entire district means entire, let us say, DDR 3. So will I go to the K East, K West Registrar, Deputy Registrar, or I will go to the DDR? I will go to the DDR. So, if the society's area of operation is in 2 or more talukas or 2 or more wards, then it will go to the DDR. So, if it is more than 2 districts, then joint registrar. If it is the entire state, it will go to the commissioner. So, this way, the delegation of power is very important and the jurisdiction is important. Section 9 is talking about again registrar. तो इसके लिए रजिस्टर का जुडिक्शन है कि नहीं है, थ्रू द डेलीगेशन ऑफ पावर वी हैव टू लुक एट इट. सिमिलरली टू refuse registration 9(2), okay, that is with the registrar, that means jurisdiction register. To maintain a register of all the society registered, to maintain the register of all the societies registered, this is not delegated to what? If you have seen that notification 9/4 nahi tha. Have you seen the notification? It was said all the powers of the registrar other than section 9/4. 9/4 is not with the DDR. It is not with the deputy registrar. So that means it is with the commissioner. Why commissioner? Because just to give you, to maintain the register of all the society registered is with the commissioner, and therefore whenever we want to register the society, they are saying our numbers have to come from commissioner. पुणेवरून नंबर येऊ द्या, त्याच्यानंतर तुम्हाला आम्ही देऊ. ते फक्त 10 नंबर देतात. So and 10 numbers are registered, then they have to give the report to the registrar. Commissioner will do this and then he will again give 10 numbers. बरोबर आहे ना? So therefore this is with the register of all the cooperative society has to be maintained by the, no doubt respect to register maintenance, but check or control is with the commissioner. To issue this registration certificate, that is with the deputy registrar. So this is how the role of registrars are there under different sections. What I have done, sections I have mentioned and I have given the role of a registrar. Section 11, to decide whether a person is an agricultural or is engaged in the business or not, belongs to a class of persons mentioned in section 22(1)(a). That means to decide whether a particular person is agricultural or not. That also, because if you are an agriculture, then only you can become a member of an agriculture society. Whether you are an agriculturalist or not, okay, to become eligible to become member or not, in the case of a dispute, it is a local registrar who has a jurisdiction. To classify all society into one or more classes and subclasses. To classify, who will classify this? Naturally, the classifications are given in the rules, rule number 10, but this is classified by the, again, registrar who registers. When you register the society, you register which class it falls. Well, there are different types of societies. Housing society, credit society, sugar factories, banks. So different types of societies are there, marketing societies. So what is that premises? What are the types of society and which sub-classification? At the time of registration, the registrar classifies. To approve the amendment in the bylaws made by the society, that's again by the respective registrar. To permit any society to undertake the activities of another class of society. So one society can take another class of society, then the registrar's permission is required. To refuse the registration of the amendment in the bylaws. To direct the society to amend its bylaws. Section 14, the registrar can say that you amend the bylaws. The direction can be issued. To approve the change in the name of the society. To approve the proposed amalgamation, transfer, division, to divide or reorganize itself. This is also with the registrar, respective registrar. To approve proposed amalgamation, transfer, division of society or conversion to another class of society. Section 17 is voluntary amalgamation division. This is compulsory. So this is through the registrar, and this is approved. This is one is approved, another is again this is also given as approval, but actually direction. To order the amalgamation 18B of agricultural society, to order amalgamation of cooperative banks, to order reconstitution of societies, compromise, to approve the creation of partnership between two societies, to order cancellation, to order deregistration of society, to order removal of any person class mentioned in section 22(1)(a). Section 22R, to decide whether a person has become a deemed member or not. To decide whether a person has become deemed member or not. To direct the managing committee to remove the name of the member who has ceased with the member. Approve the expulsion of member. To sanction admission or readmission of member. To impose conditions on the society to power. To pass order regulating the extent, conditions and manner of making loans. To fix contribution to be made by the society. To sanction declaration of dividend by society exceeding 15%. To issue certificate of recovery. To direct payment of contribution to the cooperative state category employment. To approve investment in any cooperative bank. To direct the person who has made expenditure of violation of subsection 1, section 71A, 73(2)A, 73(1)C, ID. These are various sections. Go through these sections very importantly. तो आप देखो 168 सेक्शन में how many places up to section 156. So approximately 70 to 80 sections the registrars have been given a power. Why I am highlighting this? कि when the client comes, we have to understand these are the things covered by those registrars. So he has a jurisdiction. So under which jurisdiction I have to go and get it addressed. ठीक है? So next time what we'll do is we'll try to revise the role of registrar and then of course other sections we'll take. ठीक है? Thank you very much.